My name's Alistair Edwards. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division. Before we proceed, can I just check two things? One, can everybody see me, and can you all hear me?
Yes.
Excellent, brilliant. Right, well, we're here today to begin the inquiry into the application under Section 36 of the Electricity Act 1989 by RWE Renewables UK Onshore Wind Limited for a wind farm comprising 12 wind turbines, 5 up to 200 metre blade tip height and 7 up to 185 metres on land at High Clachaig Forest. I've been appointed by Scottish ministers to hold the inquiry and thereafter report to them with a recommendation on whether to approve or refuse the application. Now, before I begin, could I just ask everybody that's here this morning to introduce themselves, and I'll start with the applicant, Mr. Fraser.
Good morning. Thank you, sir. So my name is Vincent Fraser, King's Counsel, and I'm instructed on behalf of the applicant by Mr. Gary McGovern from Pinson Masons, who I think is on the call also. And as you know, sir, my witness today is Mr. Bell, who we can also see is on the call.
And to the council, Mr. O'Carroll.
Good morning, sir. My name is Maurice O'Carroll. I'm a member of the Faculty of Advocates and an advocate in Scotland and a barrister in England. I'm here representing the local authority, and I'm instructed by Argyll and Bute Council, and also I have today here with me Arlene Knox and Mr. Mark Lodge from the Planning Department of the Council.
Thank you very much. And I've invited Mr. Grosvenor to come and join us this morning. Is it just yourself?
Yeah, good morning. My name is Melvin Grosvenor of Grosvenor Consultancy, representing local concerned residents.
Okay, thank you very much. I don't see anybody else that's joined us today, and I wasn't anticipating anyone else joining, so I'll move on. Now, we're not together, so please familiarise yourself with any exits should there be a fire. Please note that today's meeting is being filmed for live and subsequent broadcast via the DPA website. So by participating, you're consenting to being filmed and to the use and storage of images and sound recordings and any information pertaining to you contained in them from webcasting and training purposes, and for the purposes of keeping a historical record and making those records available to the public. Now, are there any questions from anybody about filming of this meeting? And by a show of hands, can you just consent that you're happy to be filmed during these proceedings? Thank you, Mr. Bell. You can put your hand down now. Thank you. And that was a very good example of, if you do have a question, you can use the raise hand function within Teams, or you can physically raise your hand, and I will try and spot you. If I haven't, then please interrupt. When you are speaking, if you can switch on your microphone, and then when you're done, if you could turn your microphone back off, that'd be much appreciated. I'm just going to check with my admin team that Mr. Lodge, can I just check, Mr. Lodge, that you're gaining access to this meeting okay?
Sir, I've just received a message from Mr. Lodge that he's required to restart his computer, so he'll be coming back on in a few minutes.
Okay, why don't we'll just pause for a few, or are we okay to pause for a few minutes and we'll just wait for Mr. Lodge to restart and come back on again? Thank you.
Sir.
Are you able to access the meeting, Mr. Lodge? You appear to be here with us. Right, good morning, Mr. Lodge. Are you able to hear us and participate now?
Yeah, I'm sorry, I can't hear anything.
We can hear you now.
Wondering if he maybe takes the headphones off and uses just the speaker on his laptop. That might be better because that's sometimes an issue.
Yes, you give that a shot, Mr. Lodge.
Wondering if you could phone him, Morris. Don't ask him to do that. If he won't hear us.
But he can't hear your suggestion. I'll just text that just now.
We could.
You should be able to change his speakers in the settings bit on Teams. I've put the instructions in the chat, so if you want to, that should hopefully help.
Yeah, maybe Morris can explain that to him on the mobile. That's a good idea.
Okay, I'll carry on and we'll see if Mr. Lodge can connect to us in the interim. And if not, we can return to him. So if you have a mobile phone or any other device, I'd ask that you keep that switched off or at least on silent today. And as we proceed throughout the week. There are going to be different topics that we'll be considering this week using inquiry and hearing sessions. These are in this order: a hearing session on policy today, a hearing session on noise tomorrow, inquiry sessions on landscape and visual impact, including aviation lighting and cumulative effects on Wednesday and Thursday, with potential run over onto Friday morning, and then a hearing on conditions on Friday afternoon. We'll start each day at 9:30 in the morning and continue till 5 p.m. at the latest, with a break for lunch. We'll also have short breaks in the morning and the afternoon, and possibly a bit more frequently, depending on how we're all doing in this virtual environment. Brilliant, Mr. Lodge. So you can hear us now, and can we hear you? Okay, we can't hear you, but we'll work on that. Right, in terms of the length of proceedings, you will have all seen the recognitions and submissions. Most of the parties are here for the whole time, but we do have some witnesses that are coming in and out for each day. We've timetabled 5 days. Can I confirm firstly from the applicant and moving round whether parties are content with the timetable and there's no changes to the timetable. Mr. Fraser, to begin.
Yes, I think the timetable seems appropriate, sir.
And yourself, Mr. O'Carroll?
I agree. I do wonder if the landscape visual sessions might be a bit tight with 1 day each, but that depends on obviously on matters as they unfold. There's one point that I'd like to raise, is that I actually have in my diary next Monday as being a reserved day, and I think that was agreed at the pre-inquiry meeting. So I think we could comfortably finish it in the 5 days. That would be normal for an inquiry of this nature. But I know you've got a reserve on Friday morning for LVI, but also there's Monday, as far as I'm aware.
I'm not anticipating needing Monday, but as a last resort, we can pull into Monday if required. Yeah. Based on the submissions that I have and the questions that I have, and obviously I don't know what yourselves are going to question the witnesses on, but I would anticipate a day per witness. Sounds quite reasonable. Okay.
I agree. I would just simply raise that as that final other reserved day, and I wasn't making a mistake about that.
No, that would be there for run over if necessary. I take it, Mr. Fraser, you'll be available on Monday if absolutely necessary.
Yes, I am. I must confess, I understood the matters the same as Mr. O'Carroll, actually. But as I said before, I'm happy with the timetable as it is, but I'm available on Monday next week if necessary.
Thank you.
Now, moving on to the site visit and consultation processes. I carried out a successful, comprehensive series of unaccompanied site inspections in, I have to say, extremely clear conditions in October. However, I did suggest that should there be a need to revisit any of the sites and/or any additional viewpoints or routes as a result of the inquiry, then those could be carried out in due course. Now, since I've carried out my inspections, 2 matters have arisen of note. Firstly, there's been a question regarding the consultation procedures on the application. And secondly, there's been late submissions from local residents, partly as a response to the consultation process. So I just want to confirm my understanding, and that is that following approval of planning consent on the site, the applicant investigated increasing turbine heights and carried out community consultation virtually with text panels and visualizations indicating up to 100-meter high turbines to blade tip. The application to the Energy Consents Unit was then made on the basis of what is before us today, 200 and 185-meter high turbines. The requisite advertisement and consultation with statutory bodies was made on that basis, as was the EIA consultation. Could I just ask the applicant briefly to explain the statutory consultation and advertisement procedures for Section 36 applications and the associated EIA, together with any additional processes that were carried out on the case? Mr. Fraser.
Sorry, sir, I was having a problem with my button. I suspect if Mr. McGovern's happy to deal with this, he may be in a better position to be able to answer that than I am. But otherwise, I'll have to take some instructions.
Good morning, Sir. Glen McGovern, solicitor representing the applicant. Yes, so I can confirm that the application was duly advertised and publicised in accordance with the EIA regulations and in accordance with the provisions of Schedule 8 of the Electricity Act 1989. And the scheme as advertised is a scheme that is before the inquiry with the mixture of turbine heights of 200 metres and 185 metres. Prior to submission of the application, you are correct that the applicant undertook pre-application consultation in relation to proposals, and that was done on a voluntary basis, as there are no statutory requirements under the Electricity Act that require statutory pre-application consultation. And as part of the pre-application process, there were exhibitions that were held virtually, and there were materials that were presented and made available for the purposes of those exhibitions. And at the point in time where those exhibitions were undertaken, the scheme was slightly different than the scheme that was subsequently the subject of the application. And what was presented in the visualisations for the exhibition stage proposals was turbines with tip heights of 180 metres at that stage. And that was subsequently refined through the design optimisation process. So what was then submitted differed slightly from what was the subject of the exhibition materials. Thank you, sir.
Right, could I ask just the council and Grosvenor Consultancy, just do you both agree that the statutory processes for consultation and advertisement have been carried out correctly in this case? I'll just ask Mr. O'Carroll first.
Like Mr. Fraser, I think I will defer to Ms. Knox. My understanding is that it has been.
I would just confirm that yes, we would consider that it has been.
Mr. Grosvenor?
Yeah, we understand there was an advertisement. The issue was obviously with the virtual exhibitions, which unfortunately happened during COVID. And the question was how many residents were aware of that and how many actually attended. But the big issue was on the basis of a single advertisement that, okay, that meets the requirements, but it's very unusual and unlikely that local residents will actually see that advertisement. So that's where the confusion has arisen. And of course, the difference between 180 and 185 up to 200 metres, local residents consider is substantial. And there should have been a further consultation, whether it be virtual or whether it be at a public exhibition, should have been provided.
Okay, but just to confirm, Mr. Grosvenor, that you understand that that was a voluntary process, the pre-application consultation. There was no requirement on the applicant to carry out further consultation.
We understand it's voluntary, but the point is that the question is whether that voluntary position is justified, quite frankly. But, you know, obviously the regulations are the regulations, but perhaps the regulations need to be looked at.
Okay, thank you for clarifying that. Much appreciated. So following the submissions from Grosvenor Consultancy on behalf of local residents, I now consider it would be useful for me to visit the properties and the holiday businesses at High Cribbsdale and North Monsdale Farm as an accompanied site inspection. Now, do parties have availability in January of next year for a visit? And subsequent to that, where would be a suitable place to meet, bearing in mind it is single track road and it is a difficult area to access with a vehicle. Do parties have any thoughts or on their availability and where to meet? If I start with Mr. Fraser and his team.
Well, sir, I'm happy to hand over to Mr. McGovern again. My understanding is that we have reasonable availability in January. Obviously, it will depend upon the precise arrangements, but I'm instructed that there should be no difficulty in agreeing a date in January. As regards where to meet, the only thing that immediately occurs to me, sir, but again, I'm happy to let Mr. McGovern speak, it is that the previous inquiry was held at the village hall in Tay and Lowen, and there is obviously some parking facilities there. So I don't know whether that might be an appropriate place for people to meet, but I'm happy to hand over to Mr. McGovern, sir.
Okay, Mr. McGovern.
Sir, having checked with colleagues in the room, we would agree with Mr. Fraser's suggestion as the most appropriate meeting point, unless one of the other parties has a better suggestion.
Okay, Mr. Carroll and your team?
I understand that availability is good in January. Tay and Loan Car Park for the community centre would be good. If Ms. Knox has anything further, she'll let you know.
I agree. Tay and Loan would be a good location to meet. I don't have any availability the first week of January or the 24th of January because I have committee that day. But that's the only times that I wouldn't be available. Thank you.
Okay, Mr. Grosvenor, yourself and the local residents, do they have availability throughout January?
I've got a fairly big problem with January. I'm not available until Tuesday the 22nd of January. I have prior commitments throughout the first 2 or 3 weeks in January. But for me personally, I don't know whether we can perhaps hone in on this date, but Tuesday the 23rd of January would be ideal.
Well, provisionally for myself, that's available as well. So can we say to parties that provisionally we'll say Tuesday the 23rd of January for an accompanied site visit, 10 a.m. And if we meet at if we're going to meet at the Tain Lone car park, we then still have an issue about driving in a convoy and then trying to find some kind of parking. So is it possible that each party provides one attendee, and could the applicant provide a vehicle that can accommodate us?
Governor, for the applicant, yes, so the applicant is happy to provide a vehicle.
Okay, and if we proceed on the basis that maybe one witness or one party from each, one person from the council, so I would guess yourself, Ms. Knox, one person from the applicant, myself, and Mr. Grosvenor. Does that make sense? Everybody in agreement with that?
Yeah, that's fine. I have actually spoken to the residents involved, and they will be available on that date as well. So that ties up quite nicely.
Okay, Ms. Knox.
Sorry, sir. Our noise consultant would also like to be present at the site visit, if that is a possibility that you'd be willing to accommodate.
Well, I have no objection in principle, other than it will be a visual inspection of the land. But if nobody else has an objection, then I'm content as long as the vehicle can take 5 people.
Well, I have to say, I'm a little concerned, sir, because as you say, it is simply supposed to be a visual inspection. And if the council's noise consultant is going to be there, it immediately raises the question as to whether our noise consultant would need to be there also. Because I really, at the moment, given there is no issue between us and the council, don't quite understand why the council's noise consultant would wish to be there.
Yeah, I tend to agree that the reasons for me wishing to have an accompanied site inspection are not directly to do with noise. They're to do with the matters that have been raised by the local residents, and the fact that I'd like to get into those properties and have a look around based on the new submissions that have been made. So I think we stick with one witness from each, and just yourself, Miss Knox, not the noise specialist.
That's fine. Thank you, sir.
Okay. Are there any more questions considering the site inspection or the consultation process? No. Okay, right, we'll move on. In terms of conditions, as you know, the single hearing session will discuss the potential conditions, but it may be that we'll discuss some conditions during proceedings. In particular, we'll be discussing the noise conditions tomorrow rather than on Friday. The potential conditions that we'll be discussing are on the joint statement of conditions that was issued by the applicant and the council. Now, could I just confirm, and we'll come back to it later in the week, but at present, do we have full agreement from parties on those now? Mr. Fraser?
I think that's so, sir. But again, I'm happy to hand over to Mr. McGivern's been keeping a closer watch on that than I have. But I think that obviously there's an issue about whether there should be a particular noise condition. But I think otherwise the situation is yes.
Mr. O'Carroll, as agreed as they can be?
As agreed as it can be, yes. I think you said earlier, had they been completely agreed? I think that the answer to that would be no, but they have been taken as far forward as they possibly can be for further discussion on Friday. Yes, that's correct.
Thank you. And Mr. Grosvenor, we'll come to the noise conditions tomorrow during our full session.
Yeah, I'm happy with that. And just to reiterate, as I sent in my email last week, fortunately, Mr. Hewson's actually in the UK, so we won't have any problems with his running over during the middle of the night. So that's worked out quite well.
Brilliant, thank you. Now, in terms of agreed statements, we agreed that statements of agreed matters would be submitted on planning and energy policy, landscape and visual impact, and we've just discussed conditions a minute ago. I've received the agreed statements on all of these topics. I've also received an agreed statement of noise from the council and the applicant. In terms of those statements, are parties content that they are as agreed as can be? Again, Mr. Fraser, Mr. O'Carroll?
I suspect, I think that is the answer to that is yes, sir, because obviously it takes two to agree. I think we've tried to narrow things down as much as we can. I think that's probably as well as we're going to manage.
And Mr. O'Carroll?
That is correct.
Now, in terms of the core documents, I received a version 4 Word document on Friday. Can I just confirm that that is the most up-to-date and agreed version of the core documents for now? Mr. Fraser?
That's the one I have, sir, so I'm hoping and assuming it is, yes.
Mr. O'Carroll?
Yeah, well, yes, I have received that. It seems to be up to date.
Okay, Mr.
It's a very necessary backstop because there's a large section of Objective Connect that's not populated. You go into section 10, which is documents submitted during the course of the inquiry, it's empty. And you have to go to the CV list. But that's the nature of Objective Connect. But that core document list is the one we've received.
Okay, I'm just looking at it just now. So the core document list has a series of hyperlinks, and I assume those all work for everybody. If you click on those, they'll open the...
Yes, they do.
They do,
Correct,
yeah.
so.
As a reporter, we don't actually have access to Objective Connect for various impartiality reasons, but... Okay, moving forward on to closing submissions. We agreed at the pre-examination meeting that closing submissions and summaries of case would be given in writing on all oral session topics. The agreed dates for closing submissions were the 8th of December for objecting parties and the 22nd of December for the applicant. Are those dates still agreed, and do parties understand what is sought in relation to this summaries of case? Mr. Fraser, firstly.
Yes, sir.
And Mr. O'Carroll?
With regard to the submission of the closing submissions, the 8th of December would be the week after, the end of the week after next. I have the substantive hearing, which is taking up all of the week after next. And I wonder if I could beg the indulgence of the inquiry to allow me until the 15th of December to lodge my closing submissions.
Right. Do parties have any comments on that? Obviously, if I extend to the 15th of December, then to give the applicant 2 weeks, we're then jumping into the Christmas holiday period. So in essence, I don't have a problem with the 15th, but it depends on Mr. Fraser's availability beyond that to produce his closing submissions.
Well, I don't have an issue as such with the 15th, but I think if it were the 15th, I would have to be suggesting that mine would come after the holiday period, because it's unrealistic to be expecting to get it during the holiday period, is the truth of the matter, sir. So I think you would really be talking about the end of the first week in January.
Okay, well, I mean, I'm happy to revise that to the 15th of December for objecting parties. So that would be the council and yourself, Mr. Grosvenor. And then if we let the applicants' closing submissions come on the 5th of January.
Thank you very much, and to Mr. Fraser for accommodating that request.
Now, finally, before we move on to our hearing session today, does anybody have any questions about the procedures or any procedural matters that they would wish to raise at this point? No. Now, there should be a full set of all the documents and precognitions on the DPA website for parties and those viewing the sessions to consult. If there are any issues accessing those documents, please let me or the office know as we proceed. Now, I'm going to start the hearing session on policy this morning. So, Mr. Grosvenor, you're not involved in that particular one, so I'll thank you for your time. We'll see you tomorrow morning with your witnesses at 9:30.
Yeah, thank you very much. Goodbye.
Thank you. Right. Now, let's move on to our initial hearing session today on planning and energy policy. As parties are aware, and for those viewing proceedings, hearings are a less formal procedure where I will lead the discussion based on the agendas for each of the sessions that have already been circulated. In effect, we'll proceed through the agenda items and I will direct questions to witnesses that in turn can initiate discussion on a matter until I consider I have sufficient information. Are there any questions about this particular process? No. Well, just for the purposes of this hearing, in case anybody's just popping into it just now, can I just ask each of the parties we'll just confirm that each of the parties who they are. So from the applicant, we have Vincent Fraser, KC, Gary McGovern, and principally David Bell be giving evidence today. Is that correct? And then for the council, Mr. O'Carroll, advocate, Mark Lodge, who works in development planning, and Arlene Knox in development management. Is that correct?
Yes, sir.
Yeah.
Thank you, sir. Hopefully you can hear me now.
I can. That's good news. I was going to ask
you.
Right. So in terms of the hearing agenda, you will have got a copy of all that. Is that correct? Yes. We've essentially covered items 1 and 2, unless anybody has any questions about the application of the Code of Practice and the hearing rules. No. In that case, we'll move through the agenda in turn, and the first item is the agreed statement, which we've already discussed in terms of it's as agreed as it can be. Could I just check? It appears reading this that there's almost universal agreement between parties in terms of the application of the energy and planning policies, other than MPF 4 policy 4, and whether or not the energy policy should be the only one that's applied, or if other policies within the development plan should also be applied to this proposal. Is that correct in a nutshell? Mr. Bell, I'll start with you.
I think generally, yes. There's just 2 comments I would make on that. I think in terms of the policies that apply and are relevant, there is agreement on that, save the council are of the view, I think, that there are certain NPF 4 policies that are relevant, policy 13, 23, 25, for example, and the applicant takes a different view on that, and we'll probably come on to those later. In terms of the position, whether it's only energy policy that applies, I don't think any party is saying that is the case. Certainly the applicant's view is that NPF 4 needs to be read as a whole, and there are various policies that will be relevant, but clearly the energy policy, policy 11, is the lead policy, and I think there is, my view is that there is agreement on them.
Okay, Mr. Lodge, the way I figure this hearing will run, I'll probably ask the Mr. Lodge, Ms. Knox, and Mr. Bell directly questions. But if yourself, Mr. Fraser, Mr. O'Callaghan, or anybody in the applicant's team want to come in, then please raise your hand. So back to the council. Are you in agreement with what Mr. Bell's just said?
Yes, sir. Sorry. Yes. I think we would be in agreement with what Mr. Bell's just said. He's interpreted everything correctly.
You have to excuse me as we go through because I'm typing your answers as we go. So moving on to item 4, the renewable energy policy and legislative background. I've summarised very briefly in A what I think has come out from that. Our parties in agreement generally that the documents referred to identify a climate emergency. They set emission reduction and greenhouse gas emission reduction targets. They identify that targets are not yet met and indeed are not a cap, and imply a need for efficient delivery to meet net zero by 2045. Mr. Bell, any comment?
Thank you. Just a brief comment. I think that is in essence is correct. But the targets, I would say, don't just relate to emission reduction. They relate to renewable generation, in particular, the onshore wind target, which is set within the onshore wind policy statement. CD 004.004. So with the addition of that, I think that's a very accurate, succinct position. Thank you.
Okay, Mr. Lodge or Ms. Knox, do you have any comments on that? Do you agree?
Yes, sir, we would agree with that.
Right. Do parties have any further comments in terms of renewable energy policy and the legislative background?
Just one additional comment, sir. I think in terms of are you looking at item B, your question B now? Yes. It was just to say that I think in dealing with NPF4, the energy policy position is embedded within it. I think that's a fair position. That was the position as of late 2022. And I would just highlight that in the applicant's hearing statement, there's 3 additional material considerations that we have referenced. One is the United Nations statement of July 2023 about the issue of global boiling, as they term it, which is CD 003.027. And the second new matter is the Committee on Climate Change report to the UK Parliament of June 2023, where they say that their confidence in the UK attaining targets for net zero has decreased, which is document 023, and that's page 14 of my hearing statement. And then lastly, the Scottish greenhouse gas statistics were issued in June 2023, that's CD 024, and they show that the target for 2021 for Scotland was missed. So the point I just wanted to make was that these additional matters that have emerged post NPF4 underscore the importance of addressing the shortfall in the targets that we've just referenced earlier. Thank you.
Thank you, Mr. Bell. Could I just confirm the Scottish greenhouse gas statistics? What year was that?
So it is published in June 2023, and it relates to 2021. And I've set that out in my table 2.2 in the hearing statement in terms of figures.
Thank you. Great. Does the council have any comments on those particular 3 documents?
No comment on those documents, sir. Thank you.
Thank you.
I think Mrs. Knox, you might have some comments with regard to other comments on energy policy. Would that be all right, thinking of that?
Yes, I think one thing that the council would just like to highlight in terms of the energy policy is that there are also provisions which seek to protect biodiversity and natural assets. And we consider that accordingly there's still a balancing exercise to be undertaken between the need to meet mitigation and reduction targets and the effects that the proposed development would have on landscape character, visual amenity and other environmental considerations, to ensure that the right development happens in the right place. And this is, reflected on page 7 of the National Spatial Strategy. Thank you, sir. That was all, just to highlight that point.
So I was just typing there, page 7 off, was that the onshore strategy?
The National Spatial Strategy in NPF4 on page 7, sir. Thank you.
Excellent. Okay, thank you very much. We're just moving on to the development plan now. Now, I think I heard and I understand on Friday that things have changed slightly here. So we'll move through these in turn. Could I just get the council to confirm, as of today, what constitutes the development plan in this case?
The development plan would be NPF4 and the Agambute Local Plan 2015. The LDP2 hasn't been adopted today. We had a request to extend the period for consideration by Scottish ministers to 56 days, so that will expire on the 18th of December. So the development plan would be NPF4, LDP1 and associated supplementary guidance.
Thank you. And we're jumping between the agenda. That's absolutely fine. That's what happens in these cases. Just to confirm, when the ministers gave you a response to extend the time to the 18th of December, did they indicate any reason why, or if any subsequent extension would be required?
We haven't had any indication of any further extension that might be required. My understanding is that there are some concerns in relation to the aquaculture policy and how it relates to the responsibilities of SEPA and Marine Scotland moving forward. So I think that's the item which they wish to discuss with us further. I'm unable to confirm whether there's anything else they may have issues with at this present time.
No, well, that in itself is useful for us today. Mr. Bell, at present, you're content that the development plan is NPF4, LDP1, and any associated supplementary guidance?
Yes, thanks. Yep.
Now, if we jump to question C there, now, obviously, as of today, the associated supplementary guidance is still in effect, but on adoption of LDP2, that will no longer be the case. Could I just ask what the council's intention regarding that guidance, the suite of guidance?
Yes, there will be some supplementary guidance that is carried forward, but that only relates to houses and multiple occupation and the Glen and forestry strategy. Other supplementary guidance will be replaced by technical notes, and we would propose to have a technical note on renewable energy, but that hasn't been progressed by the council as of yet. In the meantime, we'd be prepared to rely on the policy 30 of LDP2, which is reflective of NPF4 policy 11.
Mr. Bell, you're content with that approach in the sense that in this case, I wouldn't be applying any current supplementary guidance unless, of course, it is still the development plan at the time the decision's made.
That's right. In the Statement of Agreed Matters, Section 3, Row 6, Council agrees that the supplementary guidance would no longer be in effect if LDP2 is adopted. So that is correct.
I think maybe the most pertinent question here is to do with E. So, as LDP2 hasn't been adopted, I would hope by the 18th of December we would know more, but how should the application be assessed against the development plan? Would I use LDP1 policy and supplementary guidance, but be mindful of NPF4 in that it would prevail if there was any incompatibility? And would I apply the provisions of LDP2 as amended by the report of examination and as agreed by the council? Mr. Bell.
Yes, I think at the point of decision in your write-up, if LDP1 is still in effect, i.e. LDP2 has not been adopted, then I think your technical write-up of what the statutory development plan is important, notwithstanding section 25 of the Act doesn't apply in this case, because that could be a matter of challenge, clearly, if that is wrong, and there's examples where that has happened. So it would be important to identify exactly what the statutory development plan is, but I think convention would be that if there is a plan that is about to be adopted imminently, as Mr. Lodge has explained, then it's reasonable, in my view, to place more weight on its provisions and very limited weight on the development plan of 2016, especially given there may be some incompatibility points with NPF4. Thank you.
And the council, Mr. Lodge, would you be content with that approach?
Yes, I would say that LDP1 is now rather dated, and NPF4 would need to be the starting point for an assessment, but also to bear in mind that LDP2 is coming along, and it's, for the most part, should be compatible with NPF4.
Can I just chip in, sir? I obviously I agree entirely with everything Mr. Bell has just said, but bearing in mind that NPF4 is part of the development plan, and bearing in mind what's been said, I think, by both of the witnesses, i.e. that the intention is that LDP2, the policy basically will follow NPF4. It seems to me that when considering it, you would start with NPF4 as the primary element of the development plan to be concerned with, and I think it's agreed effectively that if there were anything further in LDP1, then really it's not going to take it very far, because obviously NPF4 is the later plan. So I think it's probably NPF4 that you need to concentrate on, I would suggest.
If I may add, sir, I think really NPF4 policy 11 is largely the same as what was in SPP, and the policy in LDP1 is in effect what was in the SPP. So there's very little difference between the renewable energy policy in LDP1 and policy 11 of NPF4. The only real substantive difference is that the reference to impacts on tourism and recreation being removed from the criteria, and but those are covered elsewhere in the criteria in policy 11. In terms of blue and green networks, for example, is in effect the recreation side of things.
Mr. Bell.
Thank you, sir. I just wanted to come back on that point that there's very little difference between NPF4 policy 11 and the LDP of 2016. The applicant takes a different view on that and considers that there are some substantive differences between the two policies. And the reasons for that are set out in the hearing statement. I think in terms of the criteria, if that's what Mr. Lodge is saying, I think that's a fair point. And there are a number of similarities, quite strong ones, except the tourism point. But there are other aspects of the policy where there are, as I say, substantive differences. Thank you.
Yes, I mean, my read over from LDP1, the renewables policy in LDP1 and LDP2 is that they're almost verbatim the same. And obviously the report of examinations removed reference to wildland from the policy and removed the spatial framework for wind turbines, but retained the tourism criterion. Mr. Lodge?
Thank you, sir. Yes, I mean, I realise that NPF4 has removed the spatial framework, and that element of LGP1 policy would no longer be applicable. Yes, thank you, sir.
Thank you. Mr. Bell's already made the point about section 25 and the fact the development plan isn't engaged in these particular applications. I just wonder, is the situation regarding incompatibility the same in terms of assessing a section 36 case? Mr. Bell?
Insofar as identifying any conflict or contradiction or incompatibility between policy documents, I still think that is important because that provides the decision maker with a guide as to which policies are going to prevail. So I think it is important to still undertake that analysis for a policy appraisal, because even although Section 25 does not apply on a statutory basis, it is still consideration of a development against the development plan is still the primary tool that decision makers use in Section 36 cases.
Mr. Lodge, any comment? Ms. Knox?
Thank you, sir. I just agree with what Mr. Bell has said in terms of it probably is important to identify where there are incompatibilities so that the lineage can be traced.
Thank you. I just want to clarify that. Okay. Do parties have any other comments in terms of LDP1 or LDP2 in terms of the application? Mr. Bell?
No, I think we've covered it adequately there. Thank you.
Mr. Lodge?
No, I have nothing further to add, sir.
We'll move on to the content of National Planning Framework 4, which takes on the rest of our agenda. We're making good headway today. So first off, do parties agree that the application is for a national development and therefore the principle of development is established? Mr. Bell?
Yes, sir. This is also in the Statement of Agreed Matters, Section 8, Row 2, specifically, where that is agreed that the principle of development is established and the respective statements of need are for the national development are set out in Annex B of NPF 4. And of course, we're dealing with National Development 3 in this case, which is page 103 of NPF 4.
And the council in agreement with that?
I'd certainly agree that NPF 4 identifies strategic renewable energy generation and transmission as a national development, and that strategic transmission or generation is identified as being over 50 megawatts. I'm not entirely sure that it's saying that the principle of development is established. NPF 4 sets out 18 national developments. Some of these are Scotland-wide, such as the renewable energy and generation and transmission, and some of them are more site-specific, such as the Edinburgh and Dundee waterfronts. So I think it's fair to say that the general principle of support for national development is established in NPF 4, but NPF 4 makes it clear that its policy is required to be considered as a whole. And there's a balancing act to be struck between that and the application of the policies in NPF 4. For instance, in terms of the NPF 4 on page 18 refers to rural revitalisation and would apply to somewhere like Kintyre. It recognises that one of the key sectors that might have potential is renewable energy, sustainable transport and green infrastructure. It includes reference to Policy 11, supporting opportunities for renewable energy development. But alongside this, it also recognises that environmental quality is a key asset for rural areas and mentions policies 3, 4, 5 and 6 on page 18 of the NPF 4. And Annex B really provides a statement of need, but it just supports renewable energy, electricity generation, repowering and expansion. It doesn't identify any specific locations and confirms it is a Scotland-wide development. So I don't think it establishes in support in principle for specific locations, just the concept as a whole.
Mr. Bell? Sorry, you're on mute, Mr. Bell.
My apologies. Just on the last point, the applicant's not suggesting that specific locations are established in terms of the principle of development. But the wording in the Statement of Agreed Matters is expressly clear. It states that development is national development, and as such, the need for it in principle is established. So that has been agreed with the Council. Page 17 of the Statement of Agreed Matters. There's a caveat to that the Council has added, which states that their designation is not intended to describe in detail how the project should be designed, matters to consider or impact assessments. That's all very fair. And it says, in addition to the Statement of Need at Annex B, decision makers for applications for consent for national development should take into account all relevant policies. That is, again, very fair and agreed. But the point is, principle for national development of this type in terms of its need is established. And as I say, that is an agreed matter.
Okay, thank you very much. If we move on, obviously the application site has existing planning permission. Does that convey that the principle for development for wind energy and battery storage is acceptable in this location? I'll go to Mr. Bell first, and then we'll come to the Council.
Thanks, sir. I would say in terms of the principle of development that we've just discussed, that would include battery storage, and we know Policy 11 includes for that. Now, the consented development did not include battery storage, but insofar as that is a relatively modest scaled element of the development, and that the consented, and given the consented development includes for related infrastructure, then it's considered that the principle of development would also extend to and encompass that related infrastructure as part of the current application. The Council makes no issue about the battery storage element, and it's an added advantage that the battery storage element would be in a former construction compound. Therefore, there would be use made of an existing development platform. And I'm not going to go into the benefits of battery storage. That's set out. That's a different point. But insofar as NPF 4 looks at the principle of development for national development 3, as I say, that would include for battery storage.
Sorry, Mr. Bell, but in terms of it having an extant planning permission for wind energy development, does that convey anything in terms of the principle of development?
The principle of development, yes, in terms of the obviously the wind, but the related infrastructure, including compounds and substation, is all an extant consent.
Mr. Lodge, do you have any comment in return?
I think Mrs. Knox is going to deal with that one. Thank you, sir.
Thank you, sir. I think the council would agree that the principle of a commercial wind farm development on this site has been established, and also, you know, obviously acknowledge that the extant permission didn't include a battery storage element. So that part hasn't been established, but obviously it would be ancillary to the main use.
Thank you. We're going to return to battery storage on Wednesday and Thursday, and I can't recall from my notes at present, but there is an objecting party or a party with concern that raised issues through battery storage. So we will return to that on Wednesday and Thursday. We move on and look at the actual policies that, oh, sorry, Mr. Fraser, yes.
Sorry, so I seem to be struggling with my microphone button. It's just a very small point. So it is covered partially, this point that you've just been discussing, also in the statement of agreed matters. You'll probably recall it's section 4.4, which I think confirms what Ms. Knox has just said, in fact. So.
Thank you. Right, if we move on to the policies themselves within NPF4, and I haven't gone to policy 1, but it's maybe worth asking parties if they have any comment about the nature and climate crisis policy to begin with. Any comment, Mr. Bell?
Just a brief one. It's covered in the hearing statement, and in summary, significant weight should be afforded to the development in line with that policy, given its principal ability to combat the climate crisis, and also in terms of the positive outcome for biodiversity that we'll come on to in terms of policy 3.
Do you have a similar view as Ms. Knox or Mr. Lodge?
Thank you, sir. Yes, I think we would agree that policy 1 is important in terms of identifying the climate and nature crisis.
Okay, but you have no comment in terms of its application to the proposal itself?
No, I mean, obviously it's a policy which is an overarching policy, and needs to be taken into consideration in relation to any development that might be proposed.
Okay, so turning to policy 2 on climate mitigation and adaptation. In terms of criterion A, could I confirm, has any life cycle greenhouse gas emission assessment been carried out for the proposal? Indeed, is one required? And as a national development, which we've already discussed, is the life cycle analysis encompassed in all similar developments cumulatively? Mr. Bell.
Thank you. Firstly, dealing with the development itself and information in the application, the life cycle greenhouse gas emissions appraisal is embedded in the overall assessment undertaken for the project, which is in Appendix 11.4 of the EIA report in terms of the carbon balance. And that just some of the headline points from that, and these are referenced in my chapter on benefits in the hearing statement, is that the carbon payback is 1.8 years, and after that period it would be net positive in terms of carbon balance. And one of the metrics provided is that over the lifetime of the project, there would be a saving of some 3.1 million tonnes of CO2, the equivalent of fossil fuel generation comparison. Now, it is not considered that policy 2 is particularly relevant. It would be relevant for more, let's say, conventional urban or industrial projects coming forward, or out of town retail, something like that. In this case, the national developments have already been assessed in terms of their life cycle emissions. So if I can just direct you to page 103 of NPF 4, the last paragraph is entitled Life Cycle Greenhouse Gas Emissions Assessment. And it states, depending on the nature of the projects taken forward and considering both direct and indirect effects, the life cycle greenhouse gas emissions assessment concludes that this development will likely have an overall net positive impact on achieving national greenhouse gas emission reduction targets. Now, there is a series of supporting reports which together make up the NPF 4 greenhouse gas emissions appraisal for national development. And I think these have been lodged, sir, with your office. But for your note, it's CD 004.010, 09 and 08. And that is the National Development Assessment in terms of greenhouse gas emissions, which is the cross-reference to this paragraph I've just read out, page 103. So in conclusion, there's no requirement for such an assessment, but one has been done in any event, as reported in the EIA report. And the key outcome is that it would be a net benefit for the project, and also in a cumulative sense for all the national developments. That is the government's view as set out in NPF 4. Thank you.
Mr. Lodge or Miss Knox, I'm never sure which one to come to. I think I'm always going to say Mr. Lodge, and then Miss Knox, if you want to come in, you can. So, Mr. Lodge, do you have any comment about that particular question?
I think that's one for Mrs. Knox as well. Thank you, sir.
I think when considering the proposal, we reviewed all of the NPF 4 policies that could be of relevance, and the council's view on this policy is that it was of very limited relevance, and we don't consider that the proposal is contrary to this policy, and that's detailed in the report of handling. I don't have anything further to add. Thank you, sir.
I mean, I realise that there's no real point of disagreement between parties, but it's just to confirm the policy refers consistently to development proposals without any caveat to say not to renewable energy developments. Is that correct? Ms. Knox?
Yes, that is correct, sir.
Mr. Bell, I take it that the proposal's been site and designed to adapt to the current and future risks of climate change, and I've given an example to do with flood risk analysis. Is that correct?
Yes, that is correct. Chapter 11 of the EIA report covers geology, hydrology, and hydrogeology, and there is an explanation in there that the development has been designed to avoid impacts from flooding, For example, 50-metre watercourse buffers have been applied, with the exception of where they need to be crossed. All crossings are designed to accommodate 1 in 200-year peak flows, including an allowance for climate change, and an appropriate drainage strategy will be developed and adhered to. It's also of note that SEPA, in the scoping opinion, took the view that the site was at low risk from flooding, and no further assessment was then, detailed assessment was needed to be undertaken on that basis. So overall, the development's been designed to maintain the existing hydrological conditions and would not be at risk from flooding.
Okay, obviously that was my particular example, was flooding, just to get us started. Are there any other challenges of climate change which this proposal should perhaps adapt to, for example, storm situations?
I think in terms of construction standards, they would meet any events like that. There's no issue with sea level surges that would also inundate beyond alluvial flooding. So I think that the view is that all necessary characteristics of the development have been properly designed at this stage for securing Section 36 consent, and clearly there's a detailed design stage to be progressed in due course, which will ensure that all British standards are met as appropriate.
Ms. Knox, do you have any comments on that particular question?
Thank you, sir. Just to assist you, I would just flag that the council's flood prevention officer has no objection to this proposal, subject to appropriate conditions, which I understand we'll discuss on Friday. Thank you. That's all.
Okay, and from the council's point of view, you're in agreement with the applicant that the construction methods, the British standards, those will all ensure that the development is amenable to any challenges that arise from climate change?
Yes, that's correct, sir.
Now, in the unlikely event, or in the event that the turbines no longer function, or we get to a point of decommissioning, is there any scope to retrofit this particular development? Mr. Bell?
Firstly, in terms of any turbine not functioning, you know that wasn't in your question, but I can deal with that. There would be a planning condition that would deal with those circumstances, and that's a fairly standard one. In terms of this policy and the reference to retrofit, that must mean that there is an existing development to retrofit measures to. But I think what this is probably driving at in this policy is, for example, buildings in particular, where it's almost 40% of emissions carbon emissions come from buildings. And there will be matters such as space heating and cooling, which could be retrofitting heat pumps in place of gas boilers and so on, and possibly introduction of district heating systems to replace individual units and so on. I think that is probably what that policy is driving at, rather than being applicable to wind farm development.
Yes, thank you, Mr. Bell. That makes sense. Council, do you have any comments on that?
Just really to reflect what Mr. Bell has said, we don't consider this part of the policy to be particularly relevant, because it seems to relate to an existing development rather than an existing permission. So as there's no existing development, we think that its relevance would be very limited. Well, maybe not relevant at all, but that's the council's view, sir. Thank you.
No, that's all right. While we're discussing this, it's just of interest to myself about life cycle analysis. Is there any proposal for what may happen following decommissioning to the turbines and infrastructure on the site? We'll go to Mr. Bell. I mean, if you have any examples as well, that would be useful.
I think this is maybe a matter for the condition section in terms of the decommissioning plan and when that will be required. And there would clearly be scope within that to take on board any best practice measures closer to the time of decommissioning that cannot be specifically identified at this time. And applicable guidance would apply and could be taken on board. I think that's probably as far as I can take it at this time.
Okay, Ms. Knox, any comment? Mr. Lodge?
I think again that we have recommended a condition to secure a decommissioning plan. So perhaps this is something that we could discuss in more detail at that time. I agree with Mr. Bell. Thank you, sir.
Okay. For myself, I feel like we've covered a lot. I wouldn't mind taking a short break just now, particularly because we're in the virtual environment. We've gone over an hour and 20 minutes now. So can I suggest that we have a 15-minute break and we come back at 11:05? Okay, I'll see you then. Thank you.
Thanks.
Okay, welcome back, everyone. We're on to item 6F, and we're looking at policy 3 on biodiversity. Firstly, Mr. Bell, how would the proposal contribute to biodiversity enhancement?
Sure. This is addressed in the hearing statement, section 4.9, and in particular, their paragraph 4.9.8, which makes a cross-reference to chapter 17 of EIA report, forestry, and the proposal for peatland restoration and native broadleaf planting, and references made there to the applicant's commitment to total implementation of a significant area of 56.2 hectares of peatland restoration and the related habitat. So that is the measure that would represent that enhancement.
Thank you. And the council are in agreement that that's the particular enhancement for this scheme?
Yes, sir, that's correct. We're in agreement.
Okay, so looking at this in a bit more detail, as Mr. Bell has said, there's proposed to be 56.2 hectares of peatland restoration and also native broadleaf forestry. Is that sufficient biodiversity enhancement to overcome any losses that are predicted? And also, would the peatland restoration occur in any case, whether or not the proposal was to proceed? Mr. Bell.
Thank you. Yes, just dealing with your last point first, I think it probably would, because the Forestry Land Scotland has a programme of peatland restoration that on their estate, but this particular project will be funded by the applicant and is a specific commitment that can be secured by way of condition. In terms of the question about sufficiency, I think at the moment, policy 3 clearly applies and refers to significant biodiversity enhancement. One of the issues that everybody is dealing with in the planning system at the moment is the lack of any specific guidance on biodiversity enhancement measures, and in particular how that relates to policy 3. And we can see that in the chief planner's letters that came out in February and June, where they do flag up that guidance is being prepared by Nature Scot, but is not yet available. So there are projects like this one that are, if you like, in a transition where they were conceived in an SPP policy framework and now have to deal with NPF4 policy at the point of decision. But so at this time, there is no quantitative measure requirement, so we need to rely on a qualitative approach. And in terms of the specifics of peatland restoration and loss, in the environmental statement, there is a reference to peat balance at Appendix 11.7. And the key figures are that the peatland loss would only be 0.07%. And the vast majority of peat, over 100,000 cubic meters, can be successfully reused on site. And the important point is that these figures do not include further restoration, because what the applicant has presented a worst case approach. So the overall conclusion that and the advice of the specialists who've been looking at that particular matter on the EIA team is that is a significant enhancement, and the peatland restoration is substantially larger than the losses as a result of the proposal. So the view is that the proposal would be in accordance with NPF4 policy 3. Thank you.
So just to clarify, the 0.07%, that's 0.07% off the application site, what's within the boundary?
No, that's 0.07% of the peatland area that is being disturbed, if you like, in the peatland balance. So, of the total peatland that is disturbed by the development, the only loss is 77 cubic meters, 0.07% of the peatland area. The majority figure is 106,429 cubic meters can be successfully reused on the site. And that's set out in Appendix 11.7, peat balance, which is reference CD 001.072, and specifically electronic pages 83 to 86. And the paragraph reference for the note would be paragraph 3.3.1 in that appendix that would give those figures.
It's very helpful, thank you. Mr. Fraser.
Yes, sir. Oh, I'm sorry, sir. I must have knocked. I wondered why you were asking me. I realised my hand's up. I don't know why my hand's up, but it was obviously my fidgety finger on the controls. I do apologise, sir.
No worries. Okay, Ms. Knox or Mr. Lodge, do you have any commentary in terms of the biodiversity balance here? Ms. Knox?
Thank you, sir. Just really to again agree with what Mr. Bell has said, that the council considers that the proposal is consistent with policy in this regard at this time.
Okay, if we move on to policy 4 then, natural places. You'll see in criterion A, the policy refers to unacceptable impacts on the natural environment. The parties have a take on what natural environment means, and what does the council consider that? How does the council consider the proposal is contrary to the provisions of policy 4? I'll start with the council first because you have that concern. Ms. Knox.
Thank you, sir. Well, the council considers that the natural environment would include all living and non-living things that occur naturally. And we would consider the landscape to fall under that category. And policy 4A states that development proposals, which by virtue of type, location, scale will have an unacceptable impact on the natural environment, will not be supported. So for that reason, because the council have concerns about the impact of this proposal on the landscape, we consider the proposal be contrary to policy 4A.
Mr. Bell, do you have a response to that?
Thank you. I think in terms of the first part of what Ms. Knox said, I think that's in agreement there. But I think in the Scottish planning system, the natural environment is used probably in a similar way to natural heritage, where it encompasses nature conservation and landscape assets. And in particular, that's expressed through designations. And we can see that this policy deals with those from the international level through to local sites of nature conservation and landscape. And I think one needs to look at the policy provisions in more detail because we get guidance for this type of land use, starting with policy 11, which makes it clear that beyond national parks and national scenic areas, development will be encouraged, facilitated and supported. And insofar as landscape is an issue, in terms of the designations, it's other parts of policy 4 that are potentially relevant. So part C deals with national designations, and these are not an issue in this case. And part D deals with local landscape areas. So that would be engaged. And my understanding is that the council has agreed that the impacts on the local landscape area, the APQ in this case, would be localised in extent. And that's the particular policy provision beyond policy 11 that needs to be examined in terms of the local landscape areas, and that will come into focus in the landscape session to come. Thank you.
Okay, so just to clarify, from my understanding, essentially the council saying that criterion 4 of policy 4A applies to the landscape generally. So none of the landscape designations that are covered in the preceding criterion so it's a general provision for any landscape. Is that correct?
Yes, that's certainly the council's understanding of that policy.
Thank you. Mr. Fraser, I'm not sure if your hand's gone up on purpose. It has. Okay. Yep.
Sorry, it has. For some reason, the microphone button seems to be very resistant to me, to my pressing it. But anyway, it's happy to mute me, but not otherwise. I think a lot of reporters would probably be very happy with that. But so I just draw your attention in this context to policy 11D, because I would suggest it is important here in placing where policy 4 might be relevant, because at policy 11D. Provides specifically, and I think it's really the point that Mr. Bell has commented upon, that development proposals that impact on international or national designations will be assessed in relation to policy 4. And that's obviously then a cross-reference back to policy 4 and the test that it imposes for national designations. But the natural interpretation of the policy, I would suggest to you, Sarah, is that outside of that, then clearly policy 11 is telling you you don't need to worry about policy 4 for proposals that come within policy 11. And so I think that's another reason why we would really say to you, sir, that obviously you'll have to look at the question of the APQ, but outside of that, really, policy 4 does not assist the council and doesn't take the matter beyond policy 11.
Does the council have any reply to that particular remark? Knox?
I think the council still considers that policy 4A is of relevance. Otherwise, why it's difficult to understand why the designated landscapes would be qualified in the other paragraphs. And instead, well, having reviewed some of the recent decisions, I mean, these other paragraphs have been referred to, but there doesn't seem to have been a decision yet that I'm aware of where policy 4A has, relating to a non-designated landscape, where policy 4A has had to be considered. So it seems that the test of 4A is still to, is still to come. But no, I think the council would continue to consider that policy 4A is of relevance.
Sorry, Ms. Knox, just in your last point there, in terms of your committee report and supplementary report, did you refer to 4A then?
I did refer to policy 4 in the I think the supplementary report it only related to adoption of NPF4, but policy 4 was referred to in the report of handling. It forms one of the reasons for the council objecting to the proposal.
Yes, obviously appreciate that the report of handling is referring to the draft NPF4, which ostensibly for the purpose of this policy remains fairly the same. But in reference to reasons for concern, just seems to be generic, referring to the provisions of the revised draft NPF4 rather than specific to policy 4. Is that correct?
I think well, policy 4 is we did consider draft policy 4, and that's why policy 4 is included in the reason for objection, because the council considers that the proposal would have an adverse landscape impact, which policy 4 seeks to protect the natural environment. Although I appreciate what you're saying, it's policy 4A is not specifically referred to in the reason for objection, sir.
Okay, any further questions about policy 4 or comments? Mr. O'Carroll? You're on mute.
Okay, that's my one time. Yeah, I just have one further addition to what Mrs. Knox has said. Sorry, I've been misnaming Miss Knox throughout. She's married under the name of Knox, so she's Mrs. Knox, not Miss Knox. That was my mistake. I'm sorry for starting that. The policy 4 has the national designations, and I take the point about the cross-reference in policy 11, but that does rather lead to the question of why it is there in the first place. Because if you took that cross-reference to policy 11 to its fullest extent, it would seem to lead you to the conclusion that where you have a designation, an area that is a landscape that is not designated on either a national or local level, then it's not something that will be protected by virtue of the balancing policies within NPF 4. And that then leads you to the question of asking, well, why have policy 4A, which doesn't relate to specific national and local landscape designations, but it does contains the words development proposals, which by virtue of the type, location, or scale will have an unacceptable impact on the natural environments and will not be supported. So if one were to take the extreme version of what's been suggested to you so far, that entire paragraph would be redundant, sir. And so I would simply seek to reinforce what Mrs. Knox has said, that it is relevant and is the basis of the council's objection to this on landscape and visual impact grounds.
Okay, thank you. Mr. Fraser, your hand's up again.
Thank you, sir. So just to come back on one point Mr. O'Carroll made there, so the fact, as I put it, that in the absence of there being an international or national designation, policy 4 doesn't apply, does not mean that landscape impacts are irrelevant, because policy 11 addresses that separately in any event, and you'll recall policy 11E2. So 11 is obviously still saying visual and landscape impacts have to be taken into consideration, but it's obviously approaching it because of the specific nature of the development here. It's approaching it under policy 11 in perhaps a different way to the way one would do for other forms of development. And it's very clear, I would submit that that's in fact the very reason why policy 4 is not applicable to this type of proposal, apart from if there's an impact upon an international or national designation, in which case you are referred back to policy 4 by 11D.
Okay, thank you. That's something I'll have to consider in writing up the report. Are we in effect splitting hairs here? If I was to find a significant effect in landscape terms, it would fall to one of these policies for me to refer to it, would it not? Either policy 11 or policy 4.
Yeah, so it would. I'd hate to be accused of splitting hairs, but the only concluding comment I'd make is that, as we've established, all policies have to be taken in the round, reviewed as a whole, and notwithstanding the national designation of this project, then it would have to be subject to policy 4 as well, for the reasons I've stated.
So if I could just come back, I don't think it is splitting hairs, I'm afraid, sir, because as I indicated, if you look at 11E2, landscape and visual impacts for this form of development are perhaps treated differently, I would suggest to you, to landscape and visual impacts for other forms of development. Because if you look at E2, there's a twofold test there. What we're told is significant landscape and visual impacts, recognizing such impacts are to be expected for some forms of renewable energy. And this is one of those where it's to be expected. And because of that, it goes on to tell us where impacts are localized and or appropriate design mitigation has been applied, they will generally be considered to be acceptable. So you're deliberately pushed along a particular way, if I might put it that way, sir, for this type of development. So there's an acceptance you will have significant impacts. And the test you then look at is it's one of two. There's two ways of passing it, so to speak. One is that the impacts are localized. And the second is that you've got appropriate design mitigation. Either way, if either of those apply, then we are told they will generally be considered to be acceptable. So I think, sadly, it isn't a hair-splitting point, if I might put it that way. It is a point that is of some significance.
Thank you, Mr. Fraser. Mr. Bell.
Thank you. I would just add that from a planning policy perspective, in terms of dealing with the landscape impact, going beyond what Mr. Fraser said about for policy 11, in the onshore wind policy statement, which provides us with a specific section on NPF 4, section 3.6 on page 19 of the statement, it refers to NPF 4 and targets, and it states that this means ensuring the right development in the right place, meeting the ambition of a minimum 20 gigawatts will require taller and more efficient turbines. And then it says this will change the landscape, and that is underlined. So again, when dealing with landscape impacts, we get the specific guidance in Part E of Policy 11, but the onshore statement gives us some further clarity that the government's expecting that there will be taller and more efficient turbines coming forward. And we've explained in evidence how that optimization for this site has taken place. And the underlining of just a few paragraphs in this statement is particularly relevant, one of which is about landscape change. So I think if policy 4A is deemed to be of particular relevance, it needs to be looked at from the perspective of that wider policy framework about landscape that the government is clearly directing a decision maker to. Thank you.
So it may come down to whether or not the word acceptable or unacceptable comes into play here. In terms of if policy 4A does apply, then possibly it's down to that word. Is that, do parties agree with that?
Yes, I think what one point, and I could find the reference for you in the Kirkin decision, which is for the inquiry, the reporter deals specifically with the right development in the right place. And he makes the point that that has to be looked at from the perspective of targets and landscape change. So that if it turns on the matter of acceptability, that has to be guided by the policy framework, which we've touched on the reference points within these two documents where there is that further guidance about localised appropriate design mitigation and also the clear indication that the landscape will change.
Sorry, could you just give me the decision again? I didn't quite hear the start of that, Mr. Bell.
It's in the Curtin supplementary inquiry report, where the reporter deals specifically with right development in the right place and how that should be approached with regard to the matter of targets for onshore wind.
I think you may find that at core document 6.7, if that helps you, sir.
What I suggest, sir, I could find the paragraph reference in the next break for that.
No, that's all right. The core document reference and the control find function will be sufficient for me. Thank you. Any other comments in terms of policy 4?
Yes,
Okay,
so I think,
yes.
sorry.
No, on you go.
Just to sort of reiterate, obviously in terms of policy 11, we're always going to expect a significant effect from a commercial scale wind farm. And I think that you're correct, sir, in your reference to whether or not it be acceptable or unacceptable in terms of the policy wording of 4A. That was all. Thank you.
Okay, if we look at policy 5 on soils, particularly if we look at criterion C2, so development proposals on peatland, carbon-rich soils and priority peatland habitat will only be supported for the generation of energy from renewable sources that optimises the contribution of the area to greenhouse gas emission reduction targets. We've covered this slightly at the beginning of the hearing, but does this proposal gain support from that particular criterion? Mr. Bell.
Yes, sir. In short, we would say it does. I think in particular, the reference to optimization is important. And again, in the application documentation with the change from sub 50 megawatt development to one approaching 100 megawatts with battery storage is an optimization. And for the first time, there is now an express reference in policy to allowing renewable development within peatland. And that has been undertaken on a satisfactory basis in relation to the peatland impact and indeed the restoration that we've covered. I would just also add that, again, in terms of the onshore wind statement, paragraph 3.3.8 is relevant, where it states that the onshore wind sector has made remarkable advances in terms of mitigation and restoration solutions for peatland. And the next paragraph states the Scottish Government wants to see the onshore wind sector continuing to contribute to peatland restoration as part of development and expects the sector to step up to the challenge of biodiversity by showcasing schemes that will not just mitigate, but will improve and enhance the natural environment. So I would say this project is probably a classic example of what the government wants to see, namely successful siting and design that can provide a net benefit, but can also optimise from a comparison with the consented development.
Just on that, Mr. Bell, is there any indication that this particular peatland restoration will be an exemplar or do something different from others?
I think in my experience, the scale is larger than what I've seen elsewhere. I can't really go beyond that in terms of the specifics, but if that is information that's required in terms of specific sub-measures, if you like, within that enhancement, I'm sure that could be provided. Maybe a reference within the EI report, which we could get shortly, that may expand on that as well.
No, that's okay. I was just pulling on your point to do with what the Scottish Government expects. In my experience, some have been involved with universities or research to do with peatland research restoration. The council, Mrs. Knox, I should say, is Mrs. correct, or I was using it Mrs. in MS, so I'm quite happy to use whatever you're comfortable with.
Oh, it doesn't really matter. I'm a Mrs. Mrs. is fine. Sorry. Well, I think the council, we don't have any concerns about this policy. We consider that the proposal is consistent with it.
Okay, thank you. If we move on to policy 6 in terms of woodland habitat, obviously there'll be a loss of forestry. Overall, I think it's 18.59 hectares. Does that loss align with policy 6 based on the fact that we also know that there'll be peatland restoration and native broadleaf planting? And I've asked a supplementary, which is, would the loss occur in any case, bearing in mind that it's a commercial forestry? Mr. Bell.
There are, just to give you a reference, you maybe got it, but in the EI report, chapter 17, there are two summary tables, 17.8, which summarizes the felling, and 17.9, which is the restocking. But in short, the answer is yes, it is considered that there is accordance with policy 6. There are also two CD documents of relevance. One is the applicant's forestry consultant response to Scottish Forestry, which is dated 25th of January, CD 1.192, and also the response from Scottish Forestry, which is CD 1.184. And in the DGA Forestry response letter, which is that's the applicant's consultant, there are forestry plans showing felling proposals. So given it's a commercial forest, there would be felling happening in any case. But Scottish Forestry is content, you will see in the response with the proposals, in that it's consistent with Scottish Government control of woodland removal policy. And again, there would be a planning condition that can be examined at the condition session that would secure compensatory planting as well.
Thank you, Mr. Bell. Mrs. Knox, do you have any reply in terms of policy 6?
No. Well, I would just confirm that the council agrees with what Mr. Bell has said, and that we consider that the proposal aligns with the provisions of policy 6. Thank you.
Okay, we'll move swiftly through. There are other policies in between, and we can come back to those if required at the end. We move on to policy 11 on energy. Firstly, Mr. Bell, could you explain to me in what way the proposal would maximise net economic impact?
Thank you. I think just in answering the question, it's worth acknowledging that at the moment there is no guidance on what that means, and I think all practitioners in the planning system have struggled to some extent with what that is. And when one looks at a number of the Section 36 decisions which have been issued since NPF4 came into force, it's been informative to understand how decision makers have interpreted and applied that particular policy provision. I think there were two references I think would be helpful. One is the planning extension Scottish Minister's decision, which is CD 006.003, page 18, where ministers simply state on page 18 that they are satisfied that the development would provide positive net economic benefits. The other decision I think is relevant is Clachaig 2 supplementary inquiry report, which is CD 009, where at paragraph 2.78, the reporter states, while an assessment of maximisation as intended by Policy 11 is not currently possible due to the lack of guidance, I'm satisfied that in this case, there is strong evidence of positive economic benefits. And the reporter went on at paragraph 2.93 to state that he found that given positive net economic impacts that would be associated with the development, he considered that that would comply with NPF4 overall. One other, well, there's two other references that I think would be helpful. In Kirkin, again, that's 006, and Shepherd's Rig, which is 017, CD 017. In both of these, again, the reporters rely on the reported net economic benefits that would result from the particular proposal and find that there would be accordance with the policy. So in this case, the socioeconomic benefits have been set out in Chapter 3 of the hearing statement, providing information in relation to the job creation in terms of full-time equivalent jobs, and also there would be supply chain benefits through the construction period in particular, and to some extent during the operational period. So insofar as that is the net economic output, which is effectively maximised because there's no additional measures that could take place, then the applicant's view is that the proposed development has sought to maximise the net economic benefits, and it would be in accordance with NPF4 Policy 11 in that regard.
Thank you, Mr. Bell. Mrs. Knox, do you have any comment in reply?
Again, I think the council would agree with Mr. Bell on this, and that in the absence of any further guidance, the council considers that they've addressed this matter appropriately and reasonably. Thank you.
Mr. Fraser.
Yes, I mean, just on that point, again, I'd suggest to you, in the absence of any guidance, I think it's reasonable for any reporter to conclude that in the absence, again, of somebody pointing out something more that could have been done that's realistic, to conclude, once you've got evidence in front of you, that there are economic benefits, that they have been maximised, because there's no suggestion by anybody that in the real world more could have been done, so to speak.
Well, that's interesting in itself. I take that point. I was just wondering, in terms of full-time equivalent jobs, in terms of the supply chain benefits, has the proposal looked to use local and regional, national supply chains as much as possible, as opposed to, say, using international supply chains?
I think on that, so the turbine components need to be sourced internationally because they're not manufactured in the UK in terms of the turbines themselves and blades. But that does leave the balance of plant contract, which would be let within the UK and probably Scotland. There used to be tower manufacturing facility at Machrihanish just down the road, and it's unfortunate that that has now gone, and that would have been an obvious candidate for the bigger element of the components of the turbines themselves. But what I would say is that the onshore wind sector deal has now been signed in the end of September. I don't think that is, maybe, I don't remember if it's before the inquiry, actually, but the onshore wind policy statement does talk about the opportunity for remanufacturing and highlights that further research on that topic is underway. And that's at paragraph 5.2.3 of the onshore statement. And it states that the following paragraph, that once that research is available, it states, we expect the report shortly and will use it to inform our approach to maximising supply chain benefits. So I think there's research that's to be undertaken by Renewable UK, there's the onshore sector deal, and I think the broader point is that with much more deployment in Scotland of onshore wind, and we know it's a doubling of existing, more than a doubling of existing capacity, that may drive that increased demand may drive supply within the UK in terms of remanufacturing. We're not there yet, but clearly the more consents that are secured, then that will potentially stimulate that element of the supply chain market. But with regard to local contractors such as McFadden's, based in a haulage contractor based in Campbelltown, and other contractors, then the likelihood is that they would be local, and they would be probably most cost effective in responding to a tender in due course. Thank you.
Thank you, Mr. Bell. That manufacturing place that you talked about, was that the one that was beside Campbelltown Airport?
Yes, at Machrihanish.
Okay. Yes, no, I saw the signage to that in my accompanied site visit, so it's useful for you to confirm that. Thank you. Mr. Fraser.
Yes, can I just say it's also covered, if it helps you at all, in paragraph 13.6.9, which is in chapter 13 of the EIAR, which is core document 1.018. That explains that, again, steps will be taken to use local supply chain. It explains what we're trying to be done, sir.
Thank you all. If we move on to criterion E, I'm interested in how parties consider that this particular criterion and the list should be addressed in terms of when I'm assessing a proposal, or ministers are these matters that should be addressed in turn, or does the wording indicate that those are just to be used when preparing the EIA report? I don't know if the caveat, the paragraph that is beyond the sub-criteria, where it says in considering these impacts, whether that gives any indication of how to apply criterion E. Mr. Bell, firstly.
Thank you. I would say it's probably both situations. I think firstly, where it states at the start of paragraph E that project design and mitigation will demonstrate how the following impacts are addressed, that would be incumbent upon an applicant to provide information in whether it's by way of an EIA report or other supporting documentation, to be able to explain to a decision maker and describe how these impacts have been addressed. And it would also be then for a decision maker to use the criteria in a development management function as appropriate. So I think, in my view, it can be used and should be used both ways in that regard.
Is that the council's interpretation? Mrs. Knox first.
Apologies, I was struggling to unmute myself. I think the council would agree with that. We would expect most of these issues to be included in an EIR, and they would be agreed before the application was submitted as part of the scoping process. And then obviously the second stage would be for the decision maker to conclude how these matters have been addressed. Thank you.
Okay, there seems to be universal agreement between you both on how to apply that. If we look at the term localized, so firstly, parties accept, and I think Mrs. Knox, you said this earlier that you did, that significant landscape and visual effects are to be expected from these type of proposals. And do you all agree that the term localized refers to geographical extent, as was expressed in the statement of agreed matters? Mr. Bell, firstly.
Yes, I agree with that. Thank you.
Mrs. Knox?
Yes, the council would agree with that, yes.
Are there any other comments in terms of policy 11? Okay, we'll move on to policy 12 then. On zero waste. I assume that any construction environment management plan and any decommissioning plan would ensure a zero waste approach to site prep, construction and decommissioning. Is that correct? Is that party's view, Mr. Bell?
Yes, that is correct. They would have an objective to ensure a zero waste approach can be achieved. And both documents would reference a construction and decommissioning resource management plan, which would implement, monitor and review waste minimisation and management, not only at decommissioning, but during site preparation and construction phases. So both the SEM and the decommissioning plan would be consistent with the waste hierarchy principles, with the aim being to prioritise waste prevention overall.
Thank you. If you go back to policy 2, we had a slight discussion about the future use of this particular development. There's obviously batteries on site, turbines themselves. So these components must have precious materials in them, minerals, the blades themselves, the concrete within the ground. I take it that these plans would look at how to use that material in terms of, would it be reused, would it be broken down? And do you have any examples of that happening elsewhere? Mr. Bell?
Yes, first point, yes. The plans that we've just referenced would interrogate the materials and would identify the appropriate zero waste approach for those following the hierarchy. There are some interesting examples. In reality now, there is one company that's been established in Scotland for reusing blades, for example, and I think it's called Reblade, and they are manufacturing benches and other furniture elements from blades. So they are starting to be reused in terms of other components. That will be probably later as there's more attention paid to that. And as decommissioning starts, as I say, the plans will make provision for identifying the appropriate waste streams and how they would be handled.
And does the council have any comment in terms of policy 12 and its application? Mrs. Knox?
I think I would agree with Mr. Bell that this matter would be controlled to agree by the SEMP and the decommissioning plans. And I think that's something that we could explore further, perhaps on Friday. But certainly the council considers that the proposal could be consistent with this policy if these conditions were applied.
Okay, we'll move on to policy 13 then, in terms of sustainable transport. Obviously, I've had a look at the EIA. Are there periods, even temporary periods, where there'd be a significant effect in terms of traffic and transport arising from the development? And in terms of the location of the development for workers coming to the site, maintenance workers, construction, decommissioning, how accessible is the site? Is there a reasonable alternative to using private vehicles? Mr. Bell.
Actually, the short answer is no, there would not be demand for significant travel. The EIA report has not identified that there would be a significant effect in terms of traffic and transportation. There are some specific references that in Chapter 14, Traffic, Transport and Access, which may be helpful in answering. If I can just give you those. Paragraph 14.3.8, which makes reference to construction personnel traffic and localities and travel routes. There is also paragraph 4.3.32, which relates to the operational phase of the development and referring to a small number of staff that would visit the site. And there's also paragraph 14.3.7, which describes the access route and the access arrangements, all which are considered to be satisfactory. And based on that approach, there was no objection or indeed any issues raised by the Roads Department in the Council or indeed from the Trunk Road Authority. There are also certain planning conditions proposed, which we will cover later in the week, in relation to traffic access and how that can be further managed. Thank you.
I just want to confirm there, Mr. Bell. So the level of traffic and the people visiting the site, I take it will be private vehicle. There isn't there. I know there's possibly a bus route that passes the site, but in reality, it's likely that most people use private transport. Is that correct?
I think that's right, subject to then the specific measures that may be in the plans that have been referenced in terms of contractor mode of transport and whether there's car sharing and other activities that can go on like that. That would be for the detail of the plans to identify.
Mr. Fraser, your hand's up.
Yes, I may have misheard Mr. Bell, but I think one of the paragraphs he referred to, I heard him say 14.3.8, and I think it may be 14.3.18 rather than 8. But I mean, you can obviously check that yourself, sir.
Yes,
it's 18. It's 18. Thank you.
Sorry, we've just lost sound.
I'm back. Can you hear that, Mr. Bell? Yeah, I hit mute. I think we've all got this. Yeah. This is Knox. Do you have any comment in terms of policy 13 and its application?
I mean, obviously, the demand for travel would be greater during the construction period. And thereafter, once operational, it would be very, very limited access that would be required. The site itself is certainly not accessible to any means of public transport. So, because it's quite some distance, obviously, from the junction with the trunk road, and I think the council, I mean, we've also taken into account the views of Transport Scotland and the roads engineer in this regard, and they have no concerns. So I think the council's view would be that the proposal is consistent with this policy as far as it can be.
In terms of accessibility, there's obviously a lot of there's some wind farm infrastructure already built along that in that area. In terms of accessing the site for turbines, blades along the A83, that's all acceptable. There are passing places. There's means of getting blades and hubs and the other infrastructure to the site.
Well, Transport Scotland have been consulted on this application, and they haven't raised any concerns that I'm aware of, subject to appropriate conditions. I think one of them may be for a traffic management plan, which would deal with all of those matters.
Right, thank you. If we move on to policy 20, blue and green infrastructure, do parties consider the restored peatland to be blue or green infrastructure? And if so, how would the peatland be managed in the long term? Would that be through the peatland restoration plan? Mr. Bell.
Thank you. I think the view is the peatland would count as green infrastructure rather than blue. I think blue is more water-based habitats, open water, rivers, streams, and so on. The restoration of the peatland will involve a full management plan, which will need to be prepared in liaison and agreement with Forestry Land Scotland to their standards. And that would form part of the overall habitat management plan that is required by proposed condition 13. And that will include specific management prescriptions to monitor the success of the proposals. And it's envisaged that the timescale of those particular management prescriptions would be agreed with the planning authority in consultation with Nature Scot and SEPA as well. So I think the long-term management can be adequately addressed by way of the measures in the planning condition.
Thank you. Mrs. Knox, you're in agreement with that?
Yes, sir. Thank you.
Turning to health and safety in policy 23, the parties agree that none of the criterion listed are relevant or likely to cause an issue as a result of the proposal. Just simply yes, if that's correct. Mr. Bell?
Yes, that's correct.
And Mrs. Knox?
Sorry about that. Yes, but obviously in terms of noise, the council has considered the proposals, whether the proposals consistent with that policy. So it has been a consideration. We don't think it causes any problems.
Thank you. Yep, that was just criterion E. I was just checking. Thank you.
Okay, thank you.
Moving on to policy 25, in terms of community well-being, wealth building, sorry. Mr. Bell, in what ways would the proposal contribute to local or regional community wealth building? And is there any suggestion of community ownership in this case?
Thank you. I think, firstly, a source of relevance will be Chapter 13, Socioeconomics, Recreation and Tourism of the EIA report. And in terms of community wealth building, there will be the socioeconomic benefits that are referred to earlier. There is also a community ownership proposal, and I've set this out in summary terms on page 29 of my hearing statement, where there is the opportunity for the community to invest in the proposal, and the summary details are set out there. I won't go through them. So there is that opportunity and commitment, which is an ability to invest up to a combined total of 49% of the project. And that's referenced, as I say, page 29 of the hearing statement.
Okay, could I just hone in on that a bit further then? When we're talking about the community here, who are we talking about? A particular body, or creating a particular body, or is there a community council or someone already involved or giving you some interest in perhaps taking this on board?
There is a degree of flexibility in the model at this stage, and it could involve one or more community organisations coming together to form a specific community vehicle. As ever with these initiatives, it's only really when consent is granted that there's a crystallisation of the potential and there's a greater momentum put together. But Forestry Land Scotland has a well-researched model which enables the community to probably secure the capacity in an easier way than with other developments in this model. But at the moment, there are no specific community organisations identified. But there is, as I say, potential for one or a number to come together to participate in the approach.
Okay, Mrs. Knox, do you have any comments on that in particular? And are you aware of any community organisations or groups that would be interested in owning part of the wind farm proposal?
I think I would just confirm that, you know, the council is aware that the proposal would have socioeconomic benefits, those which would you expect from a proposal of this type. We're also aware of the community ownership proposal as well, which I think is set out in the report of handling. I don't think the council could make a view on who should benefit from this, and we don't consider the proposal as contrary to policy, this policy in this regard, but I think we would have limited control over how it would be enforced. I don't really think I have anything else to add. Thank you.
Okay, so for myself, for my reporting purposes, the offer of community ownership is there, but at present, it would be fair to say that there's no parties that have been particularly identified that might take that on board. Is that right? I suppose my question to yourself, Mrs. Knox, was trying to understand if the council held any kind of record of any communities that were interested, and when and if an opportunity arose.
That's not that I'm aware of. It wouldn't be the development planners that would deal with that. So I'm not aware of whether or not there's a list. I'm sorry, I can't assist any further with.
No, that was just the purpose of my question. And to Mr. Bell, is that fair then? So I could report that the community ownership has been offered, but that there's no communities directly identified as yet to undertake that.
So just before I say that's the correct position. I'd want to maybe just take instructions to see if there's any information that was established through the engagement that is an indication of what that may be and whether it's confidential or not. So if I could perhaps come back on that at some point during the proceedings.
Yeah, well, we have a few more questions and then any other relevant matters. So perhaps your team in the, I'm not sure where the office is it in Edinburgh, the applicant team? It looks like Edinburgh Castle behind them, so I'm assuming so. So maybe they can have a think about that and come back at the end.
Thank you.
Move on to policy 29 then, rural development. Are these provisions applicable in this case? And in particular, I've cited a few examples. So criterion A10 on restoration, criterion B on suitable scale, siting and design, and criterion C in terms of remote rural area. My understanding is that part of this, the application site is identified in the remote rural area, but I'll get you to confirm that. Mr. Bell, applicability of policy 29.
Thank you. I would say it's not particularly relevant. I think policy 11 is the lead policy and covers all the relevant matters. Policy 11 part E Roman 12 already deals with restoration matters for energy development. And policy 29, when one looks at its wider provisions, talks about local living, transport needs, and it really conveys that it's not really about commercial scale wind energy development. The term remote rural area is not defined in NPF 4, and I know Argyll and Bute perhaps usual amongst Scottish planning authorities in that it categorises parts of its coastside area. Now, I will let the planners from the council explain that position if that applies here. But from a NPF 4 perspective, we know policy 11 is supportive of energy development coming forward in all areas except for national parks, national scenic areas. So that would be my view on the sort of spatial planning element for rural areas. But I think policy 11 covers what we need in terms of the relevant development management considerations without paying any particular attention to this policy, which I think is of limited relevance. Thank you.
Mr. Lodge, I'll let you come in just now because your hand's up.
Thank you. Can I just clarify what Mr. Bell was saying in relation to remote rural? I think NPF 4 does actually identify what should be used to identify remote rural. In the preamble to policy 29, it says the Scottish Government's sixfold urban rural classification 2020 should be used to identify remote rural areas. So I'm taking that to mean that to policy 29 applies in those areas identified by the urban rural classification. Most of Argyll and Bute is within a remote rural area. The only exceptions are the sort of around the Helensman Lomond area, so Kintyre and Clachaig Glen would be a remote rural area. Having sort of said that, I think the council would take the view that policy 29 is not directly applicable to this type of development. Our view is that policy 29 is looking at smaller scale developments. For instance, in relation to in terms of improvement of restoration of the natural environment, I would take that to be things like peatland restoration or rewilding. And again, in relation to suitable scale siting and design, I would take that to relate to smaller scale rural businesses and smaller scale residential development. And that's the sort of thing which the council through its in terms of LDP1, in terms of its policy DM1 sets a spatial strategy and sets out the various scales, and that's something which would be looked at in policy 01 in relation to towns, and policy 02 in relation to countryside areas in LDP2. It's mainly small scale development, I would say, in terms of 29.
Thank you. Yeah. Any further comments on that policy? No. Well, if we move on to policy 33, this refers to borrow pits, and I'm assuming criterion E would apply in this case. Any comments, Mr. Ball, on that particular criteria?
Thank you. Yes, just briefly, the proposed development would be in accordance with that policy. The development is time limited, controlled by a condition, and in terms of the extraction criteria that's listed in the policy, there would be a scheme required by condition for the working of borrow pits and their restoration, and the proposal for borrow pits would be, in terms of restoration, would also be enforceable. So looking at part E of the policy, these matters can all be met. Condition 27 requires a scheme for restoration in particular. I think also a point that's worthy of note on this is that the use of borrow pits would reduce and minimise traffic generation. We had a discussion just earlier on that, and the estimation is that the borrow pits, if borrow pits are used on site, they could reduce HGV movements by some 75%. So these movements are modelled in the EIA at the moment as a worst case situation, and we know that Forestry Land Scotland has used borrow pits in the area, so there is a reasonably high degree of confidence that they will be productive for the development. And if that is the case, it would be quite a marked reduction in traffic movements. Thank you.
Mrs. Knox, any comments in terms of borrow pits?
No, sir. The council's content that the proposal is consistent with that policy. Thank you.
Now, if we can return to policy, I think it was 29. Let me go back. Sorry. Right, we were talking about community ownership and whether this had come up in any of the consultation or engagement that was carried out. Any comment from Mr. McGovern and the team in Edinburgh?
Glen McGovern for the applicant. So just to confirm that, as Mr. Bell indicated earlier, there are no arrangements in place with any community body at this point in time in relation to community ownership. It's anticipated that engagement would take place post-consent in the event that consent was granted, and that tends to be the situation with most schemes that those discussions take place when there's certainty that a particular development has consent and will be proceeding. Thank you, sir.
Much appreciated. So we've come to the end of the agenda. Are there any other relevant matters that parties would like to raise in terms of energy or planning policy? I'll go around the houses. So Mr. Bell, firstly.
No, that's been very comprehensive. Thank you very much indeed.
Okay, Mrs. Knox.
I don't have anything else to add at this time. Thank you.
Okay, Mr. Lodge.
No, I've nothing further to add at this time. Thank you.
Okay, Mr. O'Carroll.
Thank you, sir. Nothing to add.
Okay, and Mr. Fraser.
No, thank you very much, sir.
Okay, well, in that case, we've got through that a fair pace. That gives us the afternoon now to prepare for the rest of the week. So unless there's any questions about procedure or practice, I'll say goodbye to you now, and we'll reconvene tomorrow morning at 9:30. You can obviously get into the call before that. So thank you for your time today, and I will see you tomorrow morning. Any procedural points before we hang up? Nope. Okay. Well, thank you for your time. I'll see you all tomorrow morning.
Thanks so much. Bye.
Thank you.